What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we take our first look at Aaron Spencer's case. A lot of allegations being thrown around, a lot of things being discussed on this case. There was a gag order that was recently lifted, so I expect more information to continue to trickle out about it. But there is so much about this case that will shock you, that should horrify you, that should get all of your antennas up to say, what the heck is going on? We're going to do kind of an overview of what the facts are, what the allegations are, what's happened legally in this case, but we are really going to focus on two factors for this video. And that is this the prototype for jury nullification? So many people have asked me about jury nullification in this case. Is it legal? Is it possible? Can the lawyers ask for it? And then number two, what the lawyers have actually been saying publicly is self-defense. Is this right for self-defense in Arkansas where this case took place? We're going to talk about the facts and those two legal principles to see how they fit in possibly to Aaron Spencer's case. I'm going to answer your questions. I'm sure you have a ton of them. Let's get to it. So there are a lot of people that are new to this case. And what we're going to do today is we're going to watch a couple videos that give overviews. We're going to read the charging documents, see what he's actually charged with. We're going to look at the self-defense in Arkansas, what they have to prove. We're going to look at jury nullification. We're going to look at all that, look at all the legal principles. But this is a case that is potentially going to trial September 22nd, which is like less than 2 months from now. So we're coming up on the trial. And to me, it's interesting that we really haven't heard a lot about this case because I don't feel like we have had a case exactly like this in the media where people would want to watch and see exactly how something like this plays out. So many people have been following and watching and being involved in so many different types of cases. Some civil cases like Johnny Depp, some cases that are self-defense like the Tennessee case or the Rittenhouse case, some police brutality cases, some cases where people are accused of ending the life of their family members, cult cases, 8-passenger type, influencer cases. There's so many different types of cases that we have followed. And there have been scenarios in other cases where people ask me, do you think this is a case for jury nullification? Peter, what is jury nullification? And almost every time we talk about jury nullification, what is the example I give? I don't know if you guys remember, but the example I give for jury nullification and where it works best and really what its purpose is, if you want to ask me, is dad walks in on somebody hurting his child and takes the life of that person. Dad walks in, sees somebody hurting his child, that person runs and flees, and they are no longer a threat to hurt them. And the dad chases him down, ends his life. Those are the cases that are basically the prototypes for jury nullification, where people are like, I would do that too. That's what he should do. That's justice. And with that in mind, and how I would usually explain jury nullification and when it's most appropriate and when I would expect it to be done, that's the example I give. So let's now take a second and watch. And this is an overview that was interesting for me. It's Jesse over at Law and Crime. We're going to watch his overview. It's about 14 minutes long. And just like a funny side story, there's not a lot funny about this story, but funny side story is Chris Hansen joins him on this episode. And you can start to understand what the background of this case is like and what the victim of this case is like. And I don't want to jump to conclusions, okay? Everybody deserves their day in court. And I know there were a lot of pending charges against the victim. I know a lot of people have said things about the defendant and that he should be charged. A lot of people saying he should be freed. We're going to listen to the facts. We're going to listen to the overview. We're going to let it play out in court. But he has Chris Hansen on, To Catch a Predator, Chris Hansen, if you guys don't know. And so they're going to talk about this case and talk about what it means and public sentiment. And that's a really big, important part about this because the judge issued a gag order almost immediately in this case. And my mind is going to so in different places in this case, but the judge issued a gag order that later the Arkansas Supreme Court found to be overbroad and overreaching. And that gag order was lifted just about a month ago. So all of the discussions that should have been had around this case, regardless of what you think about the victim, about the defendant, we should have been having discussions about this case, and we weren't because of the gag order. And now that it's been lifted, in my opinion, it's something we have to talk about. So if you guys have questions and it's something you want to talk about, we will talk about it on this channel. If it's too much, if it's too tough to listen to, and you don't want to talk about it, that's fine. And we don't have to. But I think this is one that you guys are going to have some interest in. Number one. Number two, Chris Hansen. Back to that. My funny story about Chris Hansen is before Whitney and I got married, we went on a trip with her family, and she stayed with her parents in a hotel room, and I stayed with her brother Colby in a hotel room. And her brother Colby and I and Whitney's dad were all going to go play golf early in the morning. So we all went to bed, and Colby and I watched about 30 episodes of To Catch a Predator all night, never slept. We woke up in the morning. We were like, what just happened? We didn't even wake up. It was time to go play golf in the morning. We were like, what just happened? So I did kind of love that show, I will say. The justice and to see those guys get caught, it's like a chef's kiss. So anyway, so we're going to hear a little bit from him, number one. And also the judge, I will mention, it's been alleged that the judge may not be so great in this case. And it's kind of wild to me that the judge is not conflicted off this case, because I read, and I've yet to confirm, but I read that the judge presiding over Aaron Spencer's criminal case is also the judge that presided over the victim's criminal case and let him out on a very low bond, like $5,000, which I don't understand how the judge would stay here. Unless it's like the only criminal judge in a small county in Arkansas, I don't know. But I really, really, really don't understand how that judge would continue to preside over this. Because we all know about recidivism rates and judges making these very difficult decisions on bond and whether to issue no bond or a high bond, what's fair, what's appropriate. It's a difficult position for judges to be put in, but if you end up in this situation, you should not be the judge presiding over this case. And when do lawyers and judges lose the ability to notice and to see a conflict of interest or even the appearance of impropriety is not what we want in our legal system. And there's just no way that judge should continuing to be presiding over this case. There are other judges. There's not one person that can preside over this case. I just find that mind-boggling to me. I don't know if the defense filed a motion to disqualify this judge. I would have done that. Because again, publicly, that's something I would be damning if I was the lawyers on this case. Because that just blows my mind. That absolutely just blows my mind that judge is still on this case. And I'm not saying that judge is a horrible, bad person, whatever. I know there are people that, really don't like this judge already. I have not dug in enough to have an opinion on the judge, but that is a big red flag for me. That is a huge red flag for me. All right. So let's take a listen to some of the overview here of this Aaron Spencer case. We're here today to get these facts, see what's alleged, see what's out there, and then talk about the law and what we think might be argued or happen at trial in this case, which is coming up in September, if it doesn't get continued.
A man claims he found his missing teenage daughter in a car with a 67-year-old man, an alleged stalker. And now this father is accused of killing that man, and he could be facing criminal charges. I'm going to talk with renowned predator catcher Chris Hansen to get to the bottom of this story. Welcome to Sidebar, presented by Law and Crime. Jesse Weber. Quickly, in the middle of the night in Arkansas last week. So we have 36-year-old Aaron Spencer, who reportedly called 911 to say that his 14-year-old daughter was missing. And while his wife searched the area around the home, Spencer hopped into his truck, started driving around looking for her. And that is when Spencer apparently spotted 67-year-old Michael Fossler with his teenage daughter in a car. And according to Spencer's wife, Heather, he started chasing the car that Fossler was driving. There was some sort of accident. After the crash, there was apparently some kind of confrontation between the two men, and Spencer allegedly shot Fossler, killing him. Well, when Lonoke County Sheriff's deputies arrived, they took Spencer into custody on suspicion of murder. His family was able to get enough money together for a $150,000 bail. There's a lot of different...
Sorry if I just blew everybody's eardrums because people are saying volume. So I just upped the volume. I didn't realize the volume was so far down. I apologize. Yes, he is out on bail. Spencer is out on bail. I apologize to everybody's ears. Hopefully you can hear it better. I'll back it up a little so you can hear the beginning again.
There was apparently some kind of Fossler with his teenage daughter in a car. And according to Spencer's wife, Heather, he started chasing the car that Fossler was driving. There was some sort of accident. After the crash, there was apparently some kind of confrontation between the two men, and Spencer allegedly shot Fossler, killing him. Well,
So just off of that little recitation of the facts, that Fossler had Spencer's daughter, left, Spencer chased him. There was some kind of accident. There was an altercation. Spencer ends up shooting Fossler. Okay. Just in that little factual scenario, I understand where everybody's going with the free Aaron Spencer, that this is obviously exactly what anybody would do. And I don't disagree with that. But there are so many nuances, so many it depends arguments, so many factual scenarios that are incredibly important when we get to a self-defense defense and jury nullification, which Lori said, what is jury nullification? We're going to talk about that a lot. We're going to define it. We're going to really go into what jury nullification is in this video. I'll just give you the one sentence answer is when the jury completely disregards the law. And even though they think somebody's guilty of a crime because they think it would be an injustice to convict him, they say, nope, not guilty. That's jury nullification. We're going to dig in a lot more. People are asking, did he kidnap the daughter? He interrupted a kidnapping. You know, that's certainly what it seems like. And we're going to continue to listen to the facts and see how they actually come out in court, as well as what people are surmising from different documents they've pulled from the court docket.
When Lonoke County Sheriff's deputies arrived, they took Spencer into custody on suspicion of murder. His family was able to get enough money together for a $150,000 bail. And there's a lot of different moving parts in this, including Fossler's history. So I want to bring in right now renowned predator catcher, founder of True Blue, the host of Takedown on True Blue, the host of Predators I've Caught with Chris Hansen. Who am I going to bring in? I think you guessed it, Chris Hansen, to talk more about this. Chris, good to see you.
What a wild case, Jesse.
I was going to ask you, in your experience, have you seen this kind of vigilante justice?
Apparently,
I'm sorry, I there's nothing funny about this case, nothing. But when I see Chris Hansen, all I think about is when he catches those creeps when they walk in the house and he's like, hello, were you not expecting to see me here? And the people are like, oh, I was just coming to talk. And he's like, really? Why don't you open up your backpack? Let's see what's inside and see if you are really coming to just talk. So Chris Hansen, it's funny to see him on this because I have so many memories of watching To Catch a Predator, like specifically with Colby. I probably watched 10 other episodes of To Catch a Predator in my whole life, and I watched like 30 that one night.
the guy was already warned in some method or fashion. And so they get onto this, the father does, and he finds the girl in this guy's car. Imagine the outrage. Now, you know, that doesn't mean it's okay to kill somebody because of this, but you have to take this into consideration. So I would have to believe that while there are charges here, and while it may be a question of fact for a judge or jury, the jury's going to be pretty sympathetic to a fellow who's in this position.
I'm going to make the argument, and we'll talk about this in a little bit, if you can even get a fair and impartial jury in a case like this. But your experience in your career, you've seen parents who have taken,
I've seen, it's happened.
Violent with people like this.
It's happened. It's rare.
Yeah.
Most people let the criminal justice system do its job. But I just finished a sting operation in Florida.
So again, these are the allegations. These are the things coming out in the documents that there was prior charges and actions between Fossler and Aaron Spencer's daughter. There was a restraining order. He violated that. He had 40 plus crimes out there, all dealing with these types of actions. He was known as a very dangerous man. All of that is going to be really important when we talk about the self-defense in Arkansas.
Florida, with the Polk County Sheriff's deputies down there and detectives, Grady Judd, the sheriff down there. And in a matter of days, we caught a lifeguard from a Disney resort. I mean, here's a guy who's looking at children all day.
Literally, this is my area with Grady Judd, just an hour or two north.
And he shows up at our sting house to meet up and have a sexual liaison with a 14-year-old girl because he says his fiance wasn't paying enough attention to him. We had another guy who was in the Orlando area on business as a videographer, there for a convention, from Minnesota. He lies about his name. He jerks the detectives around. He lies to me during my interview with him. And it turns out all the time, all the while we're talking to him, he is out on bail after being arrested for virtually the same crime in Minnesota. So he's out on bail for trying to have sex with a boy in Minnesota. And what does he do? He goes off on business to Florida, and he gets right online and tries to set up another sexual liaison with another 14-year-old boy in Florida.
It's pretty disgusting. And I would say, oh my gosh, shocking, but really not shocking since we covered this so much. Going back to this situation though. So Spencer's arrest, as you can imagine, it has caused a lot of outrage in the local community and online. So Heather set up a Give, Send, Go fundraising page, which has raised, our understanding, more than $100,000 to go toward Aaron Spencer's legal defense. I believe this was after an issue with GoFundMe because you're not allowed to raise money for a legal defense on that platform. So she's accepting donations through Venmo and Cash App. But a lot of people are outraged at what happened here. And a couple days after the shooting, the sheriff took to Facebook to kind of try to quell the growing unrest.
As your sheriff, it is our duty to conduct a thorough and factual investigation. Law enforcement does not file charges. We gather evidence and submit a case to the prosecutor, who will then decide whether or not to file charges. Currently, official charges have not been filed. I have not, nor will I, advocate for any specific charge.
Now, as of Monday night, it doesn't appear that the district attorney's office has filed official charges. This was more a preliminary.
This was a while back, by the way. That's why we're just getting this overview. We'll talk about, we're going to look at the charging document for Aaron Spencer.
Or preliminary murder charge, so there's not an official charge yet. But we are learning more about Mr. Spencer and Mr. Fossler's backgrounds. So we started by looking up the suspected shooter, Aaron Spencer, and we actually looked him up on Truthfinder. It's really easy to do. You just put in the person's name, location, less than a minute. Our paid subscription gave us access to all of these court records. And all we were really able to find with respect to his criminal history, peace of mind, it's one of the largest. Go to Truthfinder. Or then 13 interactions with Fossler actually started earlier this year. She wrote from Heather on the fundraising. Go to truthfinder.com/LC sidebar. So what about Michael Fossler? Well, according to a post from Heather on the fundraising page, her daughter's interactions with Fossler actually started earlier this year. She wrote, in spring, summer 2024, our then 13-year-old child was targeted, groomed, and ultimately raped by the boyfriend of a family friend. Our family did not know this monster. He just appeared in a place where our child should have been safe and got access to her phone number. And that's all it took. We let the justice system do its job. The monster who hurt our child was charged quickly, but released even faster on a $50K bond. He was awaiting court in December for several felonies in relation to what he did to our child. Now, those charges appear to include...
And if you post 10% of that 50K, it's 5K. That's where people are getting that from, that it was a $5,000 bond that he actually paid. Adventure said, just checked. Elmore, the judge for Spencer, was the judge for Fossler. Don't see any recorded motion to recuse for Spencer. I mean, that seems wild to me. I don't know if it has happened. Kibi said, how is it even allowed the judge can stay on the case of such an obvious conflict of interest? It's not necessarily an obvious conflict of interest that she would have to be recused. I think she should. I think it's a she. She should recuse herself. And if everyone, or if they have not filed a motion to get her recused, that might be why, if they haven't asked her.
Internet stalking of a child and sexual assault, but the exact details weren't available because the criminal complaint has been sealed for privacy. But Chris, that kind of gives us an idea of what we're dealing with here.
Well, yeah, obviously this guy was caught. The damage was done to this child, the grooming and the exploitation, and he doesn't learn his lesson. Just like the guys I described in our most recent sting, this guy will not stop until he is put in prison. And so that's all going to come into play when the prosecutor considers the charges against the father of the victim here. And I can't imagine that he'll see a day in prison.
The idea, though, that he goes after
Chris Hansen couldn't imagine that he would see a day in prison.
The person that he's accused of first targeting, not even going out and trying to attack someone, but going after the initial person. That's the part. And that's why people are out. He said he was out on bail, too.
He's a stone cold predator. I mean, what else can you say about a guy like this? Somebody like that is incorrigible. Somebody like that doesn't learn a lesson. Somebody like that can't be deterred. If you get arrested and you're out on bail pending criminal charges of this type, and you go back, these people in some cases are like heroin addicts.
Yeah.
They need to fulfill this fantasy. The heroin addict knows there's a 20% chance there's fentanyl in the heroin, they do it anyway. The predator knows there's a 20% chance they're going to get caught by me, by one of the law enforcement agencies around the country, but they do it anyway. They can't control it. And for that subset of people who commit this crime, there's no choice but to keep them locked up because they will offend again and again.
Now, to be clear, from a legal point of view, right, these are allegations that are being asserted. These are allegations being asserted by the Spencer family. But just to go back to this, according to Heather Spencer, she and her husband, they wake up at around 1 a.m. on October 8th to the sound of their daughter's dog barking, which they say was unusual. And when she wasn't in her bed, they started a frantic search. The two reportedly didn't know that Fossler had apparently been in contact with their teenage daughter. But Heather said that on social media, they believed Fossler had taken the girl to kill her. So when this car wreck happened, Spencer says he was able to grab his daughter from the car. Fossler attacked him, so he shot him. So kind of a self-defense argument. And the sheriff has said that they investigate every death involving a shooting like this as a homicide. And whether or not they believe that homicide was justifiable or not, that would have to be determined as the investigation progressed. But Chris, here's the thing. You put the legal aspects to the side. Whether this was self-defense or perhaps even downgraded to something like voluntary manslaughter. You're acting in the heat of the moment. You're acting under extreme emotional disturbance. Guy sees his daughter allegedly being kidnapped, and he's coming to the rescue. You can understand that. You put aside the legal aspect. I don't understand from a point of view, from a public policy point of view, how they charge him. I get it.
Yeah,
you don't want everybody taking justice into their own hands, but
yeah, especially given the fact that there is this belief that maybe he was going to kill the girl, and maybe in his twisted mind, without that witness, he doesn't face prison on the charges. We don't know. And we also don't know what was going through the father's head, but I can predict without fear of contradiction that the father was afraid. And if you're looking at your daughter in the hands of a predator, again, I don't see how this guy gets charged.
So I'll tell you how he gets charged. He gets charged if law enforcement believes the threat was over and then Aaron Spencer still took those further steps. So there are scenarios at play that we don't know exactly what happened in the interaction. We'll see what, if Aaron Spencer does testify. A lot of times in these self-defense cases, the defendant does testify. We'll see what law enforcement thinks they can prove. I don't know how they can prove anything without Aaron Spencer because none of them were there. So this is going to turn on what Aaron Spencer says happened. So there are scenarios where this doesn't end up becoming self-defense, but you can just see how they're talking about this case, that this doesn't seem like one we really need to prosecute, right? This doesn't seem like one that we need to put all of our tax dollars behind, right? That's what everybody's kind of saying, like, there's no way this guy ends up in prison. There's no way they're going to prosecute this guy, because before it ever gets to a jury and before a jury ever considers the question of jury nullification, of self-defense, prosecutors and law enforcement look at this case and make determinations. Is this something we really want to go forward on? Yeah. And what the daughter says happened. Those are the three witnesses, at least as far as I know. We don't know what else. Is there a recording? Did somebody else see something? I don't know, right? We're brand new to this case.
Say he does.
Yeah.
Let's say this is a murder charge. Finding a fair and impartial jury, given the community outrage here.
I don't see a prosecutor in a smaller town like this who knows everybody, who knows, all the players in this. I just can't imagine that this man will ultimately go to trial for any sort of homicide.
Now, to be clear, look, I've covered cases before, different kinds of
It's
abuse.
possible, and we've all seen,
Yeah,
exceptions to that common sense. Thinking.
Because murder's not the answer. I mean,
No.
look at Gypsy Rose Blanchard. Clear case, she was abused. Menendez brothers, you can make the argument that they were abused. They're going back and forth about whether it was a self-defense argument. But the point is we're not just saying murder is a justification. But here's what's interesting. The sheriff told USA Today last week, this guy that preyed upon their daughter was released on bond, and we had stopped him that night and got him with her. That bond would have been revoked. He would have never got out of jail. None of the bond companies would have let him out. We wouldn't let him out. A lot of things there. So he's seemingly acknowledging Fossler was a predator and a danger. Let's start there.
Right.
Yeah.
So maybe what he's arguing is that the father should have called the sheriff's department, called 911, and let them handle it as opposed to take matters into his own hands. That's a good argument. And then he would have been arrested and never let out on bond again until and after he faced criminal charges in court. That's a reason why maybe you detain somebody and you investigate the case and maybe there is some sort of charge filed, then it becomes a question of fact for a judge or jury. But in the heat of the moment, does any parent wait until the police get there? Do you call 911 and then give chase? Do you just do it because you act out of instinct? Those are hard questions to answer. And it's hard to really point a guilty finger at this dad for doing what he did based upon what we know so far.
And it's different than, and the allegations don't support, the facts don't support this. If he had went to the car, immediately opened fire, if there was a struggle and he was trying to get his daughter back.
It would be different if this was a case where we have seen in the past where the guy somehow sneaks a gun into the courtroom and sees him and says, you so-and-so, bam, bam, bam.
Yeah.
Or if he gets him being walked into the courthouse, or he goes to his home and kicks the door in and takes vengeance that way. But this is a case where the man who was facing criminal prosecution for grooming and sexually exploiting his teenage daughter has custody of that child. I mean, I don't know. I might come unglued myself or something like that.
And just to add to this, so Heather, on this post,
You see these two guys, right? Obviously, Hansen has a particular background, but they're sitting there being like, gosh, I could see myself doing this. I get it. What do you do in a situation? Do you see, well, maybe the worst can happen, but let's wait and see if he does do it. And I think this is kind of representative of what a jury would do. And stick around because we are going to be running a poll at the end, which I don't usually do. But in this case, I want to run a poll just for initial reactions to this case.
The fundraising page wrote, my husband is a combat veteran who has always protected his country and family. I have no doubt our child would have not come home if my husband hadn't found her. So it's a tragic case, but a complicated case and a really sad case. Again, I don't understand how you would be able to get a jury that would be fair and impartial, that wouldn't look at this and say, I can't find this guy.
Yeah, which is exactly why you have to wonder if it's even going to get prosecuted.
Yeah.
I mean, and you also have to ask the question, what are the additional charges that this guy is going to face, the predator? I mean, this obviously adds on to his.
He's dead. He's dead. Yeah,
So, so it doesn't matter now. But I mean, clearly, had he not been killed, he would have been facing a lot more time in prison.
They said they wouldn't have let him out. So look, it's a really tragic circumstance. I will say this, I can understand if they decide to charge him with either manslaughter or murder. I mean, a life was taken, I get it. But at the same time, trying to secure a conviction there, I think is going to be really, really tough.
I don't think it happens.
Chris, so good to see you. Thanks for coming on.
Jesse.
Let everybody know where.
All right. So let me answer a few questions here based on this. Peter, thank you for bringing these things to light, i.e. the judge's position in this case. I often wonder about backwoods justice in small towns. What is it? Reba McEntire? Gosh, what is it? What's the song? We talked about it already in the Murdaugh case. It's like this can't happen. We have, whether we're in Arkansas or backwoods anywhere, people in New York, California, Florida, Boston, wherever you are, shine a light on injustice no matter where it is. We've got to see what the heck is going on here. Can the daughter testify being the only one there? Absolutely. Absolutely, if she's able to. The night the lights went out in Georgia. Yes. Yes. Peter, if the dad had found the offender on his property and shot him there, would the charges be different? So I'm the worst with these hypotheticals that people give me because I need so much more information. It depends on a million different things. But this hypothetical we can kind of run through when we get to the self-defense defense. It also, I don't know if Arkansas is a stand your ground state. So, there's a lot of it depends on this situation, but in some states, yes, somebody coming on your property, if you know who that person is and you know what you think their intention is and your fear is legitimate and reasonable, then potentially, yes. Crime of passion defense, a possibility. So we're not going to dive too much into this defense, on this episode because usually a crime of passion defense is for a lesser included. Menendez tried something like this. So usually if you get a M1 charge, a crime of passion will get you like some kind of manslaughter charge in most states. It doesn't make you not guilty, like a self-defense, which is a complete defense. Sent the donation link for Aaron Pham on Facebook Messenger. Okay, so we'll post that in our comments once this live posts. We'll post that. I'll go get that from there, or John will get that from there and post it in there. Goodbye, Earl by the Dixie Chicks. Yeah. I mean, we don't want vigilante justice. We don't want people taking the law into their own hands. But man, it does not seem like Aaron Spencer did that. They had a restraining order against Fossler. They had all these allegations against Fossler. They were trying to let the legal process came out. Fossler continued, allegedly, went to the Spencer house, got the daughter again, left. Then Aaron Spencer was like, I'm going to save my daughter. That's very different than your daughter saying somebody did something and you seeking that person out, finding them and hurting them. Some people could understand that. Jury nullification might work for that too, but that's not what happened here. What was that interaction like between Spencer and Fossler? That is the big question. So let's take a look real quick at the criminal information here. Not a ton on the docket for this case, but here's the information. The state of Arkansas alleges that on or about October 8th, 2024, in Lonoke County, Arkansas, the defendant, who is Aaron David Spencer, did knowingly cause the death of another person under circumstances manifesting extreme indifference to the value of human life. So it's second degree. It's M2, extreme indifference to the value of human life. Michael Fossler is the victim against the peace and dignity of the state of Arkansas. And then there's an enhancement. Any person convicted of any offense that is classified by the laws of the state as a felony who employed any firearm, because there's a firearm in this case, of any character as a means of committing, escaping from a felony in the discretion of the sentencing court may be subjected to an additional period of confinement in the state penitentiary for a period not to exceed 15 years in violation of ACA 1691-20. So it is M2, extreme indifference to the value of human life with a firearm. That's what he's charged with. So the number one defense to this, the number one defense that makes sense here in this case, and that I've also heard the defense team discuss, is self-defense, which makes complete sense for the version of events that the defense has been explaining in the media, which is he had his 13-year-old, Fossler, the victim, had the defendant's 13-year-old daughter, had a history of hurting her, took her from the house, could do the same thing or worse that he has done in the past. And Aaron Spencer's mindset and what he knew at the time, it's different than, if my uncle or friend came and picked up my daughter and I went and hurt him. It's like, why did you do that? Did you have certain knowledge? Why would you think he was going to do something bad? Very different in this scenario, and that matters. That matters. All right, let's take a look at self-defense. use of deadly physical force in defense of a person. A person is justified in using deadly force upon another person if the person reasonably believes that that person is committing or about to commit a felony involving physical force or violence, using or about to use lawful deadly force, or imminently endangering the person's life, or imminently about to victimize the person from the continuation of a pattern of domestic abuse. So you can start to see, and if you can't read it, don't worry, I'm going to read all the words that we need to talk about. So you can see how the defense is honing in on a self-defense claim here for Aaron Spencer. And it could be Aaron Spencer himself or his daughter or both, depending on how the details of that interaction come out. A person is not required to retreat before using deadly force if the person is lawfully present at the location where the deadly physical force is used. So that's where, some of the questions about, was it on his property? It was not. Has a reasonable belief that the person against whom the deadly force is used is imminently threatening to cause death or serious physical injury to the person or another person. So this right here, that's going to be a big one for Aaron Spencer and his defense team. Except as provided is not the initial aggressor and has not provoked the person against whom the deadly force is used. Will the prosecutor try to argue Foster was trying to leave and Spencer was the initial aggressor? Eek. I will tell you right now, I would hate to be the prosecutor arguing this case. I wouldn't do it. I know I say that a lot. I wouldn't be good working for somebody at this point in my career, I don't think. I wouldn't do it. There's no way I can get up there based on the facts that I know. If there are different facts, right? If something came out where he hunted this guy down, then maybe I could understand where you get there. Does not seem to be the case. And even in that scenario, I would not want to prosecute this case and try to make these arguments against Aaron Spencer. Is not committing a felony offense of possession of a firearm by certain persons with the firearm used to employ the deadly force unless the person is in or at the person's dwelling or in the curtilage surrounding the person's dwelling. Okay, so again, some answers on that. Is not engaged in criminal activity that gives rise to the need of the use of deadly force at the time the deadly force is used, and is not engaged in any activity in furtherance of a crime, gang, organization, or enterprise as defined in 574-103. Then they define what curtilage is, domestic abuse means, physical harm, bodily injury, assault, or the infliction of fear or imminent physical harm, bodily injury, or assault between family or household members, or any S conduct between family or household members, whether minors or adults, that constitutes a crime under the laws of the state. So not a domestic relationship, I don't think, between Fossler and the child. I think it was a friend of a friend or something that built a relationship and groomed Spencer's daughter for the initial charges that were filed against Fossler. So that's what self-defense looks like. Will that apply in this case? Seems like it might, but we don't necessarily know that for a fact. And it's a scenario where, as the details come out, sometimes we can be confident in a self-defense claim, sometimes we can't. But I'll tell you what's really important about a self-defense claim. A self-defense claim in this scenario and under the rules we just read, that they have to explain that Aaron Spencer had a reasonable belief that Fossler was going to use deadly force or is going to cause death or serious physical injury to him or another person. What would give him that reasonable belief? The 43 prior charges. The allegations that he in his mind absolutely believes to be true. In Aaron Spencer's mind, he believes his daughter. He's going forward on those cases. They have a restraining order against that guy. A judge believed enough to enter a restraining order. So that's all in his mind when he is chasing down Fossler with his young daughter. So what was the reasonable belief in Aaron Spencer's mind? And that's going to be really important for the defense to present as absolutely much as they can, as much detail as they can about Fossler's past with Spencer's daughter. the more of that they can present, especially under the cloak of self-defense, which makes it absolutely relevant and appropriate at this trial, the more they can legally argue about the past and the allegations and what Spencer knows and Fossler's past actions, the more they can push the jury towards jury nullification. That's going to be important. Do we have any info about the weapon injuries, i.e. like shot? I don't know. I don't know that yet. I don't have that information, so we'll have to wait till that comes out. But it's a great question. And those are the details that we need, and we'll see how they come out as the gag order's lifted. Justifiable homicide, in my humble opinion. Potentially criminal, said the jury is going to take this guy out to a steak dinner after they acquit him. Do you think it's a better chance of self-defense or jury nullification if we could enter the jury's mind? Because if they come back with not guilty, we don't always know why. MMA legend Cain Velasquez did the same thing to his 4-year-old son's abuser. He got prison time in Cali. In my opinion, it's justifiable homicide. So we're going to take a listen now to another short video, which just gives us some background on the case. I want to listen to a couple different sources. If there's other things out there that you guys want me to listen to, I really want to get some court documents so I can actually get what's coming out in court. That's what I really liked about the Walsh case that we did yesterday. It was actually from the judge. So we're going to take a listen to just this kind of news report for 2 minutes, what they have to say. Then we're going to dive into jury nullification, and we're going to do a poll as we talk about jury nullification to see what you guys think at this point.
He's not guilty today to second-degree murder charges. Aaron Spencer is Arkansas father pleads not guilty today to second-degree murder charges. Aaron Spencer is charged in the deadly shooting of 67-year-old man he found in the car with his 14-year-old daughter. Rebecca Brown was in the courtroom today and has the latest developments on a case that got a lot of national attention.
Aaron Spencer is not a criminal.
Monday morning, Aaron Spencer uttered the words "not guilty" in front of a judge at the Lono County Sheriff's Office, where he is facing charges for second-degree murder. All this because of an incident on October 8th, where police reports say Spencer's teenage daughter was missing and was discovered by Spencer in a car with 67-year-old Michael Fossler. According to the sheriff's office, this eventually led to an argument ending with Spencer shooting and killing Fossler.
He was absolutely fearful for her life. Not to mention that she had been repeatedly the subject of multiple assaults, violent assaults.
And so obviously this is his lawyer, and obviously this is them working down the road of a self-defense defense.
A child. What are we doing here?
According to court documents, Fossler was charged in early September with 2 counts of sexual assault and 2 counts of sexual indecency with a child, along with several other charges. According to Spencer's defense attorney, Erin Casanelli, in her words, he did what any parent would have done.
We feel very...
And that is the argument down the road of jury nullification. It's not appropriate for criminal defense attorneys to argue and ask the jury for nullification. And we'll talk about why when we read some of the articles and information on jury nullification, but we'll get into it. But this is kind of what it sounds like.
Confident that this community is going to come to Aaron's side, because every one of them would have done the same thing for their child or their neighbor's child or a member of their family.
But according to prosecuting attorney Chuck Graham, who charged Spencer with second-degree murder, Spencer's fear is only part of the story.
They had a lot to say about the situation and me, but what's being put out there is not the whole story. And ethically, I can't go much further than that.
And that, when lawyers say things like that, it's things that make me go, you know, I'm like, okay, is there more? I'm going to leave the door open for that. There is more. I'm going to leave the door open to see what evidence comes in at trial. I see a bunch of people saying Melanie Little is covering this case. That's great. Love to talk to Melanie about it at some point. And it's like, yeah, there are 2 sides to the story. Certainly seems like it's all going one way. Certainly seems like that to me. And like I said, with these facts, I would have such a hard time prosecuting a case like this. Prosecutor said there's more to it. Ethically, he can't say anything more about it. There's a gag order at this point, I think, or after this maybe. And so I get it, but boy, does this look bad. He better be right. And it better be vastly different than it looks at this point.
Outside of the sheriff's office stood family and friends of Aaron Spencer. This case catching the eyes of people beyond Lono County, as many Facebook comments feel as strongly as both sides defending in the state versus Aaron Spencer.
And we look forward to the public being involved in this process, certainly more so than they were today.
A trial date will be set time out in the future for a jury trial, and we'll go from there.
That was Rebecca Brown reporting. Now, the judge set a date today for Spencer's trial and scheduled jury selection to start next March 19th.
And we know that's all been pushed back. The gag order, there was a stay. Trial is now in September. Did the daughter have a relationship with this creep? Could be the difference in her testifying. I don't want to get into that and speculate really like where things were at the time. We'll see if she ends up testifying. Peter, December 9th document gives a lot of information and is the defense response to the state's gag order. Okay. All right. Good to note. Good to note. This child has lost so much already. The possibility of losing her daddy is devastating. Keep the word out, Pita. I can't imagine. And that's the other thing that you have to think about. And again, as a lawyer, when you make certain arguments like this is what any parent would do, the child's been through so much already, she's going to testify, and you make those arguments, you can't say jury nullification, you can't argue it, but sometimes the jury's thinking about, what are we really going to do here? This is the criminal justice system. We want justice. How do we get justice in this case? D-Trug, do you see the prosecution trying to keep the victim's previous record and charges out of the trial? Yes, and I think they would be successful, but for self-defense. In my opinion, all of those charges are all the allegations are incredibly relevant for Aaron Spencer's frame of mind, for his reasonable belief of the danger he believed his daughter and himself to be in. And even if those allegations aren't true, I would argue as a lawyer, this was a man with nothing left to lose, Fossler. He was a man with nothing left to lose. Do I think that he's willing to violate a restraining order, violate his bond? He knows he's going to go away forever if he gets caught. He doesn't care. He threw caution to the wind. Nothing was going to stop him at this point except for Aaron Spencer. That's what I would argue. That's absolutely what I would argue. That those are incredibly relevant. Without those, you cannot put on a proper and full self-defense. There's just no way. You have to put in those allegations. Maybe they won't put in that he was actually charged, but I mean, the fact that he was charged matters. How desperate he was, how willing he was to break the law. And Aaron Spencer knew that. And that's what was important, is that Aaron Spencer knew that. How was this guy free? Because it was an incredibly low bond. A father protecting his child. I get it. I get it. All right, let's take a look here real quick. And let's talk about jury nullification. Just a little article here to help us. I'm going to read a little bit, and then we'll talk through some of your questions, some of your examples once we put a poll up. Jury nullification refers to a jury's knowing and deliberate. Okay, it's not a mistake, but this is something the jury purposely does. They reject the evidence or they refuse to apply the law, either because the jury wants to send a message about some social issue that is larger than the case itself, or because the result dictated by the law is contrary to the jury's sense of justice, morality, or fairness. So I think you guys can understand why this is the prototype for jury nullification, right? But let me tell you why we as lawyers can't ask for it and why it's inappropriate and unethical to ask for it. Number one, every jury selection. If any of you guys have watched it, a lot of lawyers are viewers here and members of this channel. We go and we say, will you follow the law? And if a juror says no to that, what happens? They are struck for cause. We cannot select them to be a juror. The judge will say, you've got to go. And so in jury selection, if I was the prosecutor, I would ask them about this. I would say, if you feel like this is something any parent would have done, do you still feel like you can follow the law? Do you feel like a dad that hurt somebody we believe it was a wrongful belief, or we believe that, we're going to be able to prove he wasn't actually in danger. But if this victim hurt his kid in the past, would you be able to convict if that's what the law says? It'll depend on how many facts the judge will let them get into, but I would push the judge to let me ask those questions in voir dire, because if the jury says, I'm going to reject the facts or I'm not going to follow the law, they can't be on the jury. This can occur because a not guilty verdict cannot be overturned and jurors are protected regardless of their verdict. So it happens because we don't know why a jury says not guilty. They don't have to tell us. They don't have to say it was jury nullification. They don't have to say it was self-defense. They can. There are differing perspectives on the role and basis of jury nullification in American jurisprudence. Some view jury nullification as a right, but there are examples of people being punished for disseminating the information. For instance, 2 people passed out pamphlets about jury nullification in Colorado and were later arrested and charged with jury tampering. Indeed, jury nullification is technically a discretionary act and is not a legally sanctioned function of the jury. You cannot, as a lawyer, this is just me talking again, you cannot, as a lawyer, say, we need jury nullification, disregard the law, write the law yourself, members of the jury. You can see how that would be dangerous. You can see how we don't want a legal system where whatever 6 or 12 jurors get there are making up the law as they go and doing whatever they want. A very important function of the jury is that they follow the law. Think about how important that's been in so many cases. There are other historical examples as well. For instance, in the 1800s, Congress passed the Fugitive Slave Clause, which compelled citizens of all states to assist law enforcement with the apprehension of suspected runaway slaves. Some abolitionists used the jury system to protest and refuse to convict people under these laws. This was also seen with prohibition laws. States also differ on jury nullification. In California, Judge Jan Goldsmith requested an opinion about jury nullification, in which the decision was that the California trial jury did not have the right to refuse to apply the law. The Supreme Court confirms this sentiment. So I see some people saying that certain states protect jury nullification and say that it's okay. And that may be true. I haven't read every single state constitution. But generally speaking, it is inappropriate for lawyers to push and ask for that at trial. That being said, and let's assume the defense lawyers cannot make an overt argument for jury nullification, that they can't get up there and say, yeah, he did it. Yeah, it wasn't self-defense, but who cares? Any parent would. We all know what would have happened if Fossler was allowed to continue to walk the streets. He was given more chances than he deserved. Aaron Spencer did the right thing and protected the community. And now these prosecutors who are supposed to represent the people of Arkansas are trying to convict him and put him in jail. They can't make that argument. But Kelsey, here's the poll. Assuming you didn't believe the self-defense argument, okay? So we've got to put caveats. Because if it's self-defense, then it's self-defense. It should be not guilty. And to me, sounds like a very strong argument from what we know right now for self-defense. We'll see how it all comes out at trial. But let's assume you don't believe the self-defense argument and you're a juror and you just know what we've talked about here, which is nowhere near what's going to come out in trial. I get it. I get it. Is this the type of situation that you would vote for not guilty because of jury nullification? Forget that, Kelsey. That's way too wordy. Is this case one you would consider jury nullification? So you guys all know as you're voting, we're assuming self-defense is not your vote. Is this case one you would consider jury nullification on? So you tell me. I just want to vote. I want to know, just like as people are sitting there, are you putting yourself in the juror's shoes? And if you were, are you saying, if that was me, if that was my kid, if I was Aaron Spencer, this is what I would do? I just want to know where immediately your mind goes and your feeling goes walking into this case. Because most jurors walk in, they look at the defendant, they're like, yeah, he's probably guilty. Would you put him on the stand if you were his attorney, Peter? This is always an impossible question for me to know if I don't know the defendant and I haven't talked to them and I haven't prepped them and I don't know how they come across and how they testify. I don't know all the other evidence. Is it necessary? If it's not necessary, then I'm not going to put him up on the stand. If it is necessary, then I will. But these are the types of case where I will say, to answer your question, Shelley, these are the types of case where it's more likely the defendant would take the stand. How would a jury know jury nullification is an option for them? They wouldn't. And it's not supposed to be something presented to them. Jury nullification happens when they all go back there. And let me just tell you, jurors don't need to be instructed on everything. Okay, we're having issues posting the poll, but hopefully we get it posted. Jurors don't need instructions for certain things. They go back there and they're like, you guys kidding me? This guy, we're going to convict this guy for that victim? It's absolutely happened. Where they go back there and they're like, no way, no how, not us. Over my dead body am I going to convict this guy? So they're not going to call it jury nullification. Most jurors don't even know what that means. But what they're going to do, they're going to be like, no shot, we're convicting this guy. That's what could happen. I'm not saying that's what's going to happen, but that's what could happen. And we as lawyers on the outside would say, that's jury nullification. Question, Peter, as a dad and lawyer, where do you personally sit on the issue professionally? I'm against vigilante justice and people taking the law into their own hands. If I felt for one split second that my kid's life was in danger, I would do the same thing. I can't say I would do the same thing because, again, I don't know all the details and the facts of the interaction. But if I felt like taking a person's life would save my kid, I wouldn't think twice. That's my stance. And again, I say easy for me to say, not easy for me to say, but easier said than done in the situation or scenario. Obviously, I don't know how I would actually react, but that's what I would think I would feel. I'm late and starting from the beginning. With all this said, I'm curious what your thoughts are on Cain Velasquez's case. Personally, I thought he could have gotten off with temporary insanity or something like that. So I have not looked into that one enough to have a comment on it. And people were posting there were other caveats to that case, that like somebody else got hurt when he was intending to hurt the person to protect his kid. So I don't know. It seems like there's a lot of details in that case I'd have to look at. So John said the poll is live. Thank you, Judy, for the super sticker. So go ahead and John, let me know when we have an update on the votes on the poll and we can talk about what that is. Not sure if you covered this, but it appears Fossler was an ex-police officer diver. So, I mean, that's crazy, right? If he's an ex-police officer, I've heard that as well. I mean, that's just sad and wild, right? Who wouldn't think he was going to get rid of the witness? Oh, yeah. I mean, again, that is all why I think his prior charges and arrests and allegations are relevant. He was going to get rid of the witness. Donna comes up with this on her own. A juror could say the same exact thing. Blind rage, a real defense or no? No, that's for a lesser included. So yes, it can be a partial defense, but it's not a full defense like self-defense that will get you off completely. Right now, about 1,000 votes, 95-ish% say yes, this is a case that you would consider jury nullification on. And our chat is very rarely wrong, but when they are wrong, it's usually a 55-45 or a 60-40 split. It is not. The chat is almost never wrong when it's a 90+% split on one side. Now, we don't know everything. We don't know all the details. We still want to know all the details. And if you guys are interested, hit that like button and please let me know in the comments and on social media. If this is a case you're interested in, please let me know and we will keep following it. Because I don't know a ton about it, but I would love to dive in for the trial in September. I would love to. I don't think you need nullification. I don't need to be sure Spencer believed the guy could kill his daughter. The belief he might have believed this is enough reasonable doubt for me to vote not guilty. Well, so it depends. Here's what I think, Daybreak. I think that's a great point. And I think the point is jury nullification. I have made it so black and white. I have said, let's assume they don't believe self-defense. But there could be a hybrid of jury nullification. Like, yeah, close enough to self-defense. I don't really care the technical definition of self-defense. This is the situation where it's not guilty. And I could see that being kind of the most likely outcome. Where they say close enough to self-defense, maybe a little jury nullification sprinkled in. But at the end of the day, not guilty is our verdict. I could see that. No surprise to me that our chat has their finger on the pulse. I agree juries should be required to follow the law, but where's the checks and balances for reasonable doubt, self-defense, etc.? Those tend to be emotion-driven. And this, again, could go to that hybrid. John, would it make a difference if Spencer grabbed a gun before leaving his house? Absolutely. Anything that if Spencer grabbed the gun before leaving his house. No. I mean, if he's going to save his daughter, he's allowed to take physical force that could be fatal, potentially. Absolutely. So yes, it could make a difference, but it also could play right into the argument. So Lori, hopefully that answered your question on what is jury nullification and what is self-defense. Aaron Spencer worked with the system and they failed the family. I also think this is part of his self-defense argument. I really do. Never going to find 12 jurors. People seem to think that a lot in cases. If they can find 12 jurors in Karen Reed's second trial or Johnny Depp's trial, they can find 12 jurors in this case. I'm confident. Ms. Vicky said, I would take similar action to save another's child. Save any child, frankly, if you could do it. Gary Plock, different to perp in LEO custody when shot. Yeah. And again, that's what I'm saying. There's a lot of different cases that are somewhat similar, somewhat different, but we haven't covered and really dug in to a case that is so ripe for jury nullification. And you know what I love, guys? I love the public discussion. I love learning from you guys. I love seeing what does the community think? What does the nation think? What do the people think? What does the world think about this? And we have not had one that is so ripe for a real world example and such a good discussion on the importance of following the law and if jury nullification has a place in our system. Oh, you mean find 12 jurors to convict? Okay, I thought you meant to sit on this jury. Yeah, I agree. That might be difficult. How would the jury know these facts before trial? Well, no, they'd be presented in trial. And what facts come in is what's important. That's what we're saying. We have to wait and see what facts actually come in. And then I was going to end with this. Lizette said, love the press conference with your dad and the family you represent. Thank you so much, Lizette. Yeah, we had a press conference with the family of Jose Castro, the victim in the Clearwater ferry boat crash. Criminal charges were filed against the driver that hit the ferry boat, taking the life of our client, Jose Castro. We represent him on the wrongful death civil side, but the criminal process is moving forward. We're working with and talking to prosecutors and law enforcement in that case. My dad and I, if you guys have interest, we may do a video on that. We are going to post some clips from the press conference on our channel. It might be on our Lawyer You Know in Shorts channel if you guys want to give us a follow and a subscribe over there as well. If you're interested in that case, there's going to be some interesting things coming out in that case as well. And it's really important to follow. And it has some really important community aspects, especially for Florida and any other state where the waterways are significant and people are on the waterways, and we want to protect and make sure the waterways are safe. Sandy said, you are a prosecutor on this case. How much does the community outrage something influence your decision to prosecute? Community outrage, it would be something I considered, but more importantly, I would want to make sure I'm doing the right thing, protecting the community, because I'm a voice of the community. I'm a protector of the community. I am for the people of the state of Arkansas. That is the job of a prosecutor. So it should come into play. It should be important, but you can't just always go where the wind blows. You have to be resolute. You have to do the right thing, and you have to be confident that you know what the right thing is and you're going to do the right thing as a prosecutor. Thank you, Dr. Ryan. And that's all we got for this one. I appreciate you guys joining me. Make sure you hit that like button and make sure you're subscribed if you want more on this case. I appreciate you guys so much for joining me, for your questions, for your votes on the polls, to let me know what you think as a community and what is the vibe out there, and the pulse of what's going on, what you guys are thinking and feeling. I appreciate it so much. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.